Good morning, sir. Are you Jermaine Duhan?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, yes.
Mr. Duhan, in cause number 24 DCCR 2464, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Duhan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right? Good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Lewis. Good morning.
Good morning.
You're Christopher Bushnell?
Yes, ma'am.
So, Mr. Bushnell, you were previously in court, entered pleas of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and the second-degree felony offense of engaging in organized criminal activity. Those were for agreements of a 10-year probation deferred in each of those cases. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections to the report?
Just that it may indicate that he doesn't take full responsibility, but after speaking with him, he does take full responsibility for his actions and involvement in both cases.
I've also reviewed jail incident reports. Have you both been given a copy of those?
Yes, Your Honor.
So you're 17 now,
Yes, ma'am.
I don't think he turns 18 until.
December 26th.
And Judge, if we need to go back and renegotiate an offer, obviously he's not even out of custody yet, and this is how he's acting.
Well, and
Your Honor, obviously due to his age, I want him to have the opportunity to get his life together, obviously not going into adulthood with felony convictions. I have preached to him the importance of following the rules and not.
you can't do it, can you?
Okay.
You cannot. 21 incident reports since January 25th of this year. 21. Fighting, calling officers names, stealing food, instigating fights, being a bully to other people in the dorm. Ridiculous. So if you can't follow rules in the jail, what makes you think you're going to come in here and I'm going to say, sure, go be on probation out in our community? After y'all shotgun, I mean, this is serious. I'm tired of the shootings. I'm tired of people, you could have killed somebody. And because you accidentally didn't kill somebody, you get to get a probation. Not today. If I could send you to ISF, I would consider it. I can't. At this point, I'm going to reject the plea agreements. We will set the cases for a review in about 30 days. Let's see where we are, go over his options, y'all talk. If I can always do, upfront time, but we've got to get to a certain point where that would make sense. And so at this time, I'm just going to reset the cases. Again, I'm rejecting these plea agreements. And let me tell you, you get more of these, it's only going to get worse. I'm going to see them. A jury's probably going to see them a jury will see them if you go to trial. And you're going to end up in prison for up to 20 years because you can't follow the rules in our jail and you're acting like a little punk. So go stop acting like a punk, prove that you can behave, then we'll see what happens. When you come back next, I'll see how many of these I have. Go back with the bailiff. Mr. Blunt, you're on probation for an extremely serious offense. I could be sending you to prison today for a very long time for violating your probation. Sounds like probation's willing to work with you. You've done some positive things while you're on probation, which are good, that you are going to treatment. You've made a great deal of progress. Those are the things that I'm really concerned about, but they're not the only things I'm concerned about. You've got to follow all of the rules, not just some of them. You've got to get this drug deal kicked. If you don't, you're going to go to prison over drugs instead of really what the underlying offense is. Do you understand?
Yes, ma'am.
We're going to give you the opportunity. We're going to give you treatment. You take advantage of it and change that part of your life. Great. If you don't, you're back in here and this is going to be zero tolerance. There's no messing up at this point.
Yes, ma'am.
Do you understand?
Yes, ma'am.
If the treatment that you're getting through JCDI is not enough, it's going to be up to you to be a grown-up and go to probation and say, I'm feeling tempted, I need more help. Nobody wants to go into custody for more help, but it's better to go in for 90 days than it is to go to prison for up to 20 years, right? Okay, so in cause number 15-21380, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the recommendation of the district attorney in probation and continue you on probation in order that you enter and successfully complete the cognitive track of the ISF program. And then when you're released, you will enter and successfully complete the JCDI program. These programs are doing two different things. The first one is to help you make better decisions. It's about thinking and making better decisions. The JCDI program is the drug intervention program to help you with what you need, hopefully, to stop using drugs. So you're going to have all the tools that you need to make these better decisions, and then it's going to be up to you. Continue doing everything you're supposed to through your treatment and other things like that. It sounds like that hasn't been an issue. You're still on a deferred probation. You're still not convicted of this offense. If you're back in here again, in all likelihood, you will be convicted and you will be going to prison for a very long time. Do you understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you. Thank you, Your Honor.
Good morning, sir. You're Lawrence Marks. And in cause number 24, DCCR 1763, Mr. Marks is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I made a new offer to Ms. Praza today after discussing the case with her. She is asking, and I'm not, and I agree, we're asking for a reset so they can discuss that offer and look at some evidence in the case, Judge.
All right.
That's fine with me.
Okay, so I'll do one last reset. We will get an announcement, make sure, go over everything with Mr. Marks. Mr. Marks, when Ms. Praza comes to visit with you, she'll give you all your options, show you everything, and then we'll get an announcement at the next court date, whether or not it's going to be a plea or a trial, okay?
And what I'd stated was I would keep the new offer open for one more.
Okay,
court
perfect.
appearance, and then-
Perfect. All right, thank you, sir. You can go back with the bailiff.
All right.
Thank you, Judge.